Hey guys, today we are going to talk about the defense of fair comment as a defense to a defamation lawsuit. Now, the rationale for the defense of fair comment is the right to free speech and the promotion of open discussion between people. However, this defense of fair comment extends only to comments or expressions of opinion, but not to factual statements. In order to rely on this defense, the defendant has to satisfy four limbs. Number one, the words that are complained of are in the nature of comments, although they may consist of or may have a reference to facts. The court in the English case of Branson and Bauer number 1 held that a comment is something which is or can reasonably be inferred to be a deduction, an inference, a conclusion, a criticism, a remark, or an observation. Lord Porter in the English case of Kemsley and Fool used the example of the comment, "Such conduct is disgraceful." Now, when a person says such conduct is disgraceful, he's making a comment or giving an opinion on the conduct of somebody based on certain facts. Whereas, and therefore he will be entitled to the defense of fair comment. But if the same person said, Peter is guilty of disgraceful conduct without elaborating or providing facts or factual basis to back up his statement that Peter is guilty of disgraceful conduct, then he will not be able to rely on the defense of fair comment. The second thing that the defendant has to show is that the comment is based on true facts. The defendant, the person being sued for defamation, has the onus, the burden of proving that the facts are true. There is a difference between the defense of justification, which was discussed in the earlier video, and the defense of fair comment. In the English case of London Artist and Littler, the court held that under the defense of fair comment, the defendant only needs to prove the basic facts are true. On the other hand, for the defense of justification, the defendant not only has to prove that the basic facts are true, but also have to prove that the inferences are true. The Singapore Parliament passed this piece of legislation, this law called the Defamation Act, which provides that where a defamatory statement comprises partly of facts and partly expressions of opinion, the defendant, the person being sued, doesn't have to prove the truth of every fact in the defamatory statement, as long as the expression of opinion is a fair comment based on the facts, that may be proved. The third thing that the defendant has to prove to rely on the defense of fair comment is that the comment is fair. What is the meaning of fair? Well, the English court in Turner and Metro Goldwyn Mayer Pictures held that a fair comment is an opinion that a fair-minded person could honestly hold with some allowance given for prejudices and exaggeration. You may then ask, what's the meaning of honestly hold? Well, the Singapore Court of Appeal in the case of Chen Cheng and Central Christian Church elaborated on the meaning of honestly held. The Court of Appeal stated that the word honestly is used in the objective sense. It means a reasonable person attests. The comment must be one that, objectively speaking, a fair-minded person could honestly make given the proven facts, unless in making the comment he is motivated by malice. Malice means evil, ill intent. The last limb that the defendant has to prove to rely on this defense is that the comment is in the matter of public interest. Now, you may ask, what is public interest? Lord Denning in the English case of London Artist and Littler clarified the meaning of public interest. Lord Denning stated that whenever a matter is such as to affect people at large so that they may legitimately be interested in or concerned at what is going on or what may happen to them or to other people is a matter of public interest, and everybody is entitled to fair comment on such matters of public interest. Let me give you a few examples where the comments were held to be in the public interest. In the English case of South Hatton Coal Company Limited and Northeastern News Association, the unsanitary conditions of the premises owned by South Hatton Coal Company, the unsanitary, that means dirty, filthy conditions of premises owned by the plaintiff, was held to be in the public interest. In the Singapore case of Aaron and Joseph and Cheong Yip Seng, it was held that statements concerning a religious sect and its practices are a matter of public interest. Once the defendant manages to satisfy these four limbs of the defense, he will be entitled to the defense of fair comment. But the defense can be defeated by proof of malice. What is malice? Well, it is ill intent, it is something like evil. An opinion is made maliciously if the defendant did not genuinely believe in what he stated. For example, the opinion was motivated by spite, ill intent. This was endorsed by the Singapore Court of Appeal in Wee Hong Leong and David Ban. When determining if the comment was malicious, the court would examine the state of mind of the defendant, the person who made the defamatory statement and is relying on the defense. The plaintiff has to prove malice on the part of each defendant who relies on the defense. So, for example, if someone made a Facebook post, okay, and then several people make comments about the Facebook post, okay, and if the plaintiff sues everyone who commented on the Facebook post, he has to prove malice on the part of each person that he sues, not just one or a few. Everybody that he sues, he has to prove malice if he wants to defeat their defense of fair comment. So thanks for watching this video on the defense of fair comment in the context of defamation.